Welcome to Law Talk. Today we're going to be discussing question, will my attorney take my case? We have Steve Gokberk here this morning. Steve works at Salinger, Sack, Kimmel, and Bavaro, which is a New York personal injury and medical malpractice firm. Steve has been in the Rising Stars list of the Super Lawyers publication for 2 consecutive years. The Armenian Bar Association ranked him top 40 nationwide Rising Stars, and that was in 2019. I was there. It was a great evening. Steve and I are, old friends and good colleagues, and we have volunteered for the Society for Orphaned Armenian Relief. So how do you decide whether you're going to take a case or not?
All right. Good morning, Ruben. Thank you so much for having me join you today on your interview series. I really appreciate this opportunity. And thank you for that question. I think it's a very important question for attorneys in the personal injury business, as well as for the potential client.
Okay.
What is involved in whether or not an attorney is going to take your case? And there's a lot involved in that question. But on a very basic level, the most important thing is, before making any decision, is that initial client meeting, that initial intake, where you get the opportunity to meet the client and you make a determination whether that client is a right fit for your firm and whether the client feels like they're a right fit for you. And I think it's very important that you have that first meeting to be able to determine that, which I'm sure is very similar to your work, where you have to meet your potential client before anything can ever happen.
Of course, yeah. I mean, that initial contact with the client, I think, is critical. In my cases, because it's divorce or family law-related cases, it's high emotions. So the client will be in an emotional state. They will tell me things that may matter to them at that point, right there and then. But down the line, it's that those things may be not so relevant. The things I'm referring to are my partner, my husband, my wife, is bipolar. Every single, every single client that walks into the door believes that their, soon-to-be ex is crazy.
Similar to us. For personal injury cases, in my firm, we have a strong reputation. We're very selective with the cases that we get. So often the clients that we have coming into our office or that we are going to see are people who are catastrophically injured. These are people who are going through the most significant pain that they could ever have imagined in their lives. And that heightens the emotions on their end as well. So it's important for you and your business, as well as mine, to make sure that the client respects and understands the attorney that they're meeting, and that the attorney is
Right.
empathetic, sympathetic to the client's needs, but also, and I think this is what you were getting at, you still have to filter through whether or not the facts are sufficient to be able to be one that your firm or my firm would want to take.
Right. And that's actually a good thing that you brought up the word filter, because attorneys, we are the filter, right? The initial filter to taking a case to court. As many of our viewers may know, there is a huge backlog in courts. We have many fine judges out there, and court attorneys and staff, but the volume of cases is just astronomical. So the attorneys, we are considered, or we are officers of the court. So we are basically the first filter to filter out, the meritorious cases, as opposed to ones that, that do not have merit.
Exactly. So for our firm, and going back even to the original question, is this a case that our firm would take or that your firm would take?
Right.
You have to keep in mind the merits. You are an officer of the court. When you meet that individual and you're doing your initial investigation, you have to make sure that the case that you're bringing is one that you feel or know, based on your research, based on your investigation, is one that holds merit and that the court is going to be willing to listen to, and that you are going to, in my line of work in particular, be able to present the best case to a jury down the road. And
Right.
all of those determinations are in part are actually made during that initial intake, that initial meeting with that client.
Right. And it's important to know that, you know, you on the first day when you meet that client, you yourself are thinking, you know, what the jury is going to think about this case, right?
That's correct. I
Um,
have a partner who says that, you know, we're doing our trial preparation when you're first meeting the client. That
yeah.
is your first opportunity to start to prepare and look down, where is this case going to? And you get to do that even during that first meeting and when you're beginning to do that investigation to determine whether it's a case for you.
Right. And frankly, you know, and I know you, Steve, I know how you litigate. You are always looking at the trial and how are you going to fare, you know, in front of the jury and the judge. So tell me, what do you do to vet your cases?
All right, very good question. So, of course, during that intake, getting the initial story from your client, that's very, very important. You want to hear their version of what occurred. So, in my work, we handle individuals who've been seriously injured in motor vehicle accidents or have been injured in a terrible accident at a construction site or slip and fall or trip and fall situations. So, immediately, what's important for us is to be able to verify, did this accident occur the way that our client is saying the accident occurred? So immediately we're thinking of ways of how do we verify what occurred? How do we find out what is the version of what happened? And how is it that we're going to eventually present that version of the accident to a jury down the road, or sooner than that, to an insurance adjuster, opposing attorney, or what have you? So it's important that you ascertain, were there accident reports? Are there any photographs? Did the police arrive at the scene? Did the ambulance arrive at the scene? You're looking for anything that confirms how the accident happened initially. And that's in all types of, you know, again, motor vehicle, construction site, what have you. You're looking to investigate using your law firm's resources to find out the truth and using those whatever cost necessary to get to that truth.
Right. So, and just for the viewers, this initial part of the case is called the pre-claim investigation. And generally speaking, this involves interviewing your client. In my case, actually interrogating my client, because I do not want to go and say things to an adversary, or to a court attorney or to a judge, and then find out later that these things are false. And that, you know, in terms of attorney credibility, is very, very important, especially at least in my cases, because divorce cases and family court cases, they don't have juries. Okay, so the final person that makes the decision on my client's cases is the judge. So you know what? I better have, over the years of practice, I better have developed trust, credibility between myself and the judge. So when I say something, the judge knows that this is actually the case. So that's why I will interrogate my clients. I will make them give me backup information about what they claim happened. Backup information for me could be, you know, text messages, email messages, you know, I mean, of course, and the generally speaking, you know, I would ask for birth certificates, you know, a certificate of marriage, and all of the background information together with that. Yeah, go ahead.
Yeah, so that's interesting because that actually is in a way it's similar to my line of work, because for us we also have to do a similar sort of verification vetting process as well. I briefly discussed the liability portion. We have to do an analysis regarding who was at fault for this accident. Can we establish that the other party was at fault? But another major aspect, and it's maybe a little obvious, but I handle personal injury cases. So I have to be able to verify what are my client's injuries. I need the client to provide me with the information that I need regarding doctors that they've seen, hospitals that they've been to, procedures that they may have had, diagnostic studies that they might have had. But also, and this is where the credibility and the truth portion is so important, I need the client to also tell me regarding their prior medical history. Did they ever have a prior motor vehicle accident? Did they ever have a prior slip and fall accident? Did they ever injure the part of the body that they're claiming is now injured in this accident that they're coming to me for? And that's a really, really important aspect into whether a law firm will take a client's case.
Right, right. So I mean, but you don't just take the client's word for that, right?
Right.
You in addition to what your client tells you, what else do you do?
Right. So we would have to, there's different searches that you can perform in order to determine whether there were any prior claims. There's different things that you can do on the public record. Right. But that aspect is so important regarding having a client be truthful regarding their medical history, because that aspect is something that actually an attorney can handle. You know, if once you, and for you as well, right? If you know something that perhaps could be considered a negative, and you know that immediately, you could begin to strategize and begin to look at the medical records and begin an analysis in light of knowing that past medical history.
Right.
And something that you pointed out before with opposing counsel and with the judge who you're demonstrating credibility to, you need to know whether or not your client had a prior issue, a prior accident, prior criminal record, a prior psychological history, what have you, because if the other side knows it or you make a misrepresentation regarding that to a judge, that's how you lose credibility. And that's how you lose credibility with the jury. You have to be able to draw the poison out before the defendants do. And you have to demonstrate confidence for your clients. And it's very similar to us. And depending on the analysis, depending on, in our situation, the medical records or the prior history, you can make determinations that is kind of similar to, let's say, a client who had an issue with alcoholism. Right. Perhaps your client had stopped or had been going to Alcoholics Anonymous and had been dry, so to speak, for perhaps years. Right. And then, in my situation, is a victim of a serious car accident, is a victim of a horrible products liability situation. Right. And then that brings them back to something that they had been off of, that they hadn't been doing. And then this accident was a precipitating cause of beginning to drink again or reuse drugs or abuse pain medication, which is unfortunately something that you do see because it is often prescribed in personal injury cases or in injury situations as well. So there's different perspectives, but you need to be able to know about that before the case begins. Just like you said, you have to be able to present that first or be able to be confident in arguing that point instead of being surprised by it or having a judge be surprised by it.
Right. So, I mean, if anything that I want the viewers to take out of our little talk here is, one, give us the bad news. Give us the bad news first, right? Two, credibility. You do not come in and lie to your attorney because, whatever you like, or hide things from your attorney, not lie, right? Hide things or misrepresent things to your attorney, because this is the guy or gal that is going to be going and arguing for you, okay? And you do not want that person to be second guessing you. So credibility, you build your credibility with your attorney and you better hire an attorney that has credibility in the outside, in the legal world at large, right?
Absolutely.
So
Reputation is everything.
credibility and the bad news first. Yeah. So, is there anything else that you guys, that you do in preparation in your, initial intake?
Right. So with the initial intake, you're trying to get as much information as possible regarding the client, while also building a bond with them.
Right.
As important as it is for my firm to decide whether the client has a potential case that we would take, it's important for the client to feel that trust that you had mentioned in the attorney. It's an initial beginning of a relationship, of mutual respect that the attorney and the client have to have. So on a basic level, you have to build that relationship. Number two is doing what I said earlier. You have to be able to investigate the facts. You have to get as much information as possible. The background information, details regarding the accident scene. And that could be so many different things in a car accident case, just regarding the roadway. How did it look? How many lanes of travel were there? The speed limit, the traffic control devices, an accident location. There's so many factors that go into whether or not the liability, the fault portion, can be established against the other attorney. But at that intake, you have to find out that information. And then based on that information, you are able to do the investigation that you need to do.
Right.
Getting to the clerk's office, contacting an investigator potentially in order to facilitate certain aspects of the investigation. Right. The attorney contacting witnesses, non-party witnesses, going to the accident scene, which I cannot stress enough. It's very important to actually go to the accident location. And the attorney should do that, either with their client or on their own. Best with the client, so that the client and the attorney can go through the situation together.
Yes.
Point to me where the sidewalk was misleveled. Can you show me where in the supermarket the liquid was forming? There's so many different things, countless amount of cases, but the investigation is not done with that initial intake. You have to continue to follow up with your client. You have to continue to investigate. And oftentimes, that's what you need to do to determine whether or not that case is right for you, whether that place is right for your firm. And again, my firm is more selective. So you have to be able to determine whether or not the liability portion is strong enough to present to a judge. Mm-hmm. Are the injuries significant enough to go to a judge? And not that our firm is not sympathetic to that, but you have to make an analysis. You have to find out from the client, and then with your own verification regarding the medical records. What do the medical records say? What do the diagnostic studies show? Do the X-rays demonstrate a fracture? Do the MRIs demonstrate a shoulder tear or an ACL tear? These are things that we have to do. So our job and your job, or every job as an attorney, is never complete, of course, with that first intake.
Right.
And that determination is always something that's going to be developing as you continue your investigation.
Right. Okay. So for the viewers, I want to point out one thing that Steve said that I think is worth is a mark of a good attorney, and he is my friend, so obviously I think highly of him. But the mark of a good attorney is a person that is doing the preliminary investigation, and they want to go to the scene of the accident, and they want to see exactly how what that intersection looks like, or what that construction site looks like. So it is important, because if that attorney is going to go and describe a particular thing to a judge or to claims examiner or anything, like, they are going to be able to do that better, because they were there, they saw exactly how everything is. So that is a mark of a very good attorney. This initial intake, this initial investigation results in you deciding whether you're going to take the case or not. So that's one. Are there other things that you look at to decide whether you're going to take the case or not?
I mean, there's a countless number amount of things that you are looking at in determining whether you are going to be taking a case.
Right.
And it's important that you are able to get those facts as soon as possible for the client in order to make that determination. But for my line of work, it really comes down to whether or not we find that the client is credible. We find that the medical records do demonstrate that there's a difference between potential injuries in the past and versus the injuries that are being claimed in our case. Of course, for attorneys, a very important factor is doing legal research. We have clients come in who are catastrophically injured. They have been in horrible accidents, but they're novel accidents. They're issues that we don't see every day. It's not simply a rear-end motor vehicle accident.
Right.
There's situations that occur that require the attorney to research, to use their Westlaw access, their Lexis access, and find out whether the law supports our claim regarding how the accident occurred. And in situations where it's not as simple as a rear-end car accident case,
right,
there are situations where you do have to do research. For example, the construction site accident cases. Those cases are very fact-specific, and they're governed by the labor law. And you have to be able to demonstrate whether or not, under one of the sections of labor law, whether an industrial code was violated. Determining whether the industrial code was violated and whether it qualifies under the labor law requires fact-specific legal research. And for our practice down in the city area, Long Island, Westchester, there's major differences between the appellate division and the first department and the second department on similar facts. So it's really, really important that you, as an attorney, based on that initial investigation, the facts that you're ascertaining in the beginning, whether or not it even fits under the law.
Right.
And that's something that has to be done in order to present to your client to let them know, this is what we researched. This is what the law is saying. This is what the law is saying regarding whether this qualifies as a New York City building code violation. This is what the law is saying regarding whether this qualifies under the labor law. This is what the law is saying in this area regarding the maintenance of sidewalks during a snowstorm. This is what the law is saying regarding the maintenance of a sidewalk in Westchester. There's differences.
So you have a prospective client that's walked into your door, badly injured, right?
Yes.
And obviously, but then you have to go and do some research and find out whether the place where he was injured and the people that were in charge of that place had any duties towards him. I mean, of course, he is injured, but if the law says that, well, maybe the owners there were not actually the people responsible, then who are you suing? Right. So who are you going to go after? So these are, very important considerations that the attorney has to go through. And frankly, if your attorney does not go through these things, he or she will drag on the case, which will take maybe a couple of years. And then guess what? Some judge is going to dismiss that case. And all of your time and your efforts are going to be, out the door, right?
Right. That's absolutely true. And it leads to another point where it's really important that during that meeting, the client's expectations are set. Questions are often asked regarding, how long does the case take, and how much money am I getting, and all of those things. In the beginning, it's very important to set those expectations and have the client recognize that it's probably way too soon to answer a lot of those questions that they're having.
Right.
But it's important to be on the same page with the client regarding that, so that there is no mistrust or false promises made to the client.
Exactly.
And I think that's a very important portion to any intake. And that also leads to whether or not we take the case. Our firm is selective as in regards to that. If we have a client who is going to perhaps maybe have a misunderstanding regarding how the judicial system works or how quickly things process, and they have a false understanding or meditated understanding of how they think this is supposed to go better than their attorney, then perhaps that relationship isn't the best. And it doesn't happen often, but it does occur where you have people who need to discuss or express their feelings regarding what their expectation is. And sometimes those expectations are unrealistic. And if the potential client doesn't want to accept that perhaps a case can take a certain amount of time, that's a problem on both ends. And it was a great point that you made. Otherwise, you're bringing a case forward. It's going to take an unknown amount of time. And if that client believes that that case is supposed to be resolved in 2 weeks and it's taking 2 years, you're not going to have a happy client. And like you said, you're going down a road that potentially does not end well for the attorney as well if the judge does dismiss the case.
Right. And again, this is where, once again, credibility comes in. Just like you, the client, has to have some credibility towards the attorney certainly, without any doubt, has to be credible to you. And if the attorney has failed to, mention things in the original intake, or that attorney is, unresponsive to your phone calls and, is unresponsive to your questions, then you're kind of, you don't trust that attorney. Credibility is really key to any relationship, and just like it is, for the attorney-client.
Absolutely.
Okay, all right. So this was a great talk. Thank you, Steve. I really appreciate you coming on, and thank you everyone for joining us on LawTalk, and I hope that you will catch our next video.